Welcome to our first discussion of contract law. What is a contract? A contract is an agreement between two or more people regarding something, the subject matter of the contract. It's usually an exchange of promises. Contract law is different from tort law in that tort law involves a relationship between two parties that's involuntary. In other words, one car smacks another on I-5 and somebody's injured. There's a relationship between those people, but it wasn't voluntarily entered into. Contrast that to a contract which people enter into all the time. Classic example being buying coffee or a newspaper. You may not actually say any words, but money is exchanged, and the subject of the contract, the coffee or the newspaper, is given to you. Contracts can have different characteristics. They can be for big things like a Harrier jet, or small things like a diamond or a Timex watch. Most contracts today are considered informal contracts. That doesn't mean that they aren't signed or they don't have notaries, but the category of formal contracts is reserved specifically to checks, guarantees, certificates of deposit, and some very narrow things like that that are statutorily defined. As the book tells you, contracts can be express or implied. Sometimes people use the word express to mean written contracts, but actually express means written or spoken. Anytime the subject matter of the contract is clearly specified, it can be an express contract. Contrast that to an implied contract. An implied contract is one where there may just be conduct or there may be some spoken words, but they don't clearly specify an offer and an acceptance. They don't identify aspects of the contract. They're just implied. It's a much more informal situation, like buying a coffee or a newspaper. Contracts can be legal or illegal. If they're illegal, then they're not valid contracts. If the subject matter of the contract is something that is illegal, like buying cocaine or marijuana in another state besides Washington, that would be an illegal contract. The book summarizes existing common law of contracts into 6 elements, and what they say is if any of these 6 elements is missing from a situation, there may not be a valid contract. You need all 6. If one is missing, then somebody could challenge the contract and say it's not a valid contract. We'll talk about each one of these in turn later. An offer shapes the deal. The offeror is the one who identifies the preliminary terms that are going to be used as part of the contract. One looks for an offer as a required element of a contract. The acceptance, under traditional common law rules, is supposed to mirror the offer. So the offer and the acceptance mirror each other, and under the old common law rules, if they don't look exactly alike, the offer is withdrawn. There is no contract formed because there's been no meeting of the minds. One of the basic requirements of contract law is that there's a meeting of the minds, which simply means that the parties agree on all essential terms of the contract. Is there consideration? Consideration is the bargained for exchange, the subject matter that is of the contract. When you're buying a newspaper, it's the newspaper. You're buying coffee, it's the coffee. It's the thing that the parties wish to exchange for money or some other form of repayment. Legal subject matter, we've just said there needs to be a legal subject matter for it to be a valid contract. Capacity, that refers to the individual's ability to be old enough and sane enough to contract, which we'll talk about later. And then intent to contract, that's a really key theme. Obviously, if you need to have a meeting of the minds to have a valid contract, you need to have intent, which is the party's internal belief or desire to contract. And there are things that show there couldn't have been an intent to contract, such as when there has been fraud involved, which is essentially lying, or mistake, or duress, which is essentially gun to the head saying, you must sign this contract. So these are the 6 elements of a valid contract. There's an old joke that says, when you think like a lawyer and you give somebody an orange, this is how it looks, according to traditional contract language. I hereby give and convey to you all in singular my estate and interest, rights, claim, title, claim, and advantages of and in said orange, together with all of its rind, juice, pulp, and seeds, blah, 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 blah. This is an example of a kind of an old school thinking of contract law drafting. The current trend is toward plain language, simple language, easy to understand language, not saying things in triplicate and duplicate, which was the original way of doing things. This is not in the book, but I think it's important to get some context about when contracting takes place. Here's an example of the typical time frame of contracting. Somebody forms an idea to enter into an agreement, then they contact the other party or parties and have negotiations. Then they have an offer and acceptance, which forms the agreement. That's the meeting of the minds on the key terms. After the actual contract is formed with the agreement, then there'd be a performance phase. There may then be a breach by one or both parties. Then there could be some more negotiations about how to resolve that breach. If those don't pan out, there may be a lawsuit which assigns damages to one party or the other, and then there'd be a judgment and execution on the judgment. So it's a fairly involved process if they're to form a contract and to go through its life and to see it result in a final judgment. So here are some of the questions we're going to address, and I'd be interested in hearing if you have some additional questions as well. How do you know when you've moved from a negotiation to an offer acceptance? That can be hard to sort out. How do you know when there's a binding agreement versus a mere negotiation? How can you distinguish a gift from a contract? How do you know what are the terms of the deal? Does the deal have enough formality according to generally accepted legal principles? How do you know when someone's breached? What are the remedies for breach? How do you draft a deal that will hold up in court? And how do you draft a deal to use maximum vagueness where it suits you? She says wryly, tongue in cheek. If you have particular questions that you're interested in because of your background and where you think you're heading with your career, please post them to me, maybe in the questions for Jessica, and I will be happy to address them in this course. This course is about 80% basic contract law and 20% negotiations. The negotiation piece comes from the book Getting to Yes, which is an excellent classic primer in the area of negotiation that I think, if you haven't read it recently, will open your eyes to a wealth of negotiation possibilities. I like this quote: "We negotiate constantly with everyone, yet few truly master the principles of negotiation." So this book will help you reflect on how you negotiate. Are you satisfied with your strengths and weaknesses? And what would you like to accomplish for yourself? Here's the essence of the book. Don't bargain over positions. Don't get stuck into an ego fight where you have your heels kicked in and you're refusing to budge. Separate the people from the problem. Treat the problem as if it's something that you're both trying to work on, as opposed to something that is just a person issue. Focus on interests, not positions. This means think about what a person might... Sorry about that. Think about what a person might want as opposed to their position. Think about ways to invite them to have mutual gain, and insist on using objective criteria when you're going to measure something. There are resources that can help you with this class. There's a nutshell by West Publishing Company on contracts in the library. And I want you to note, when you read the case that is part of chapter 1. You only need to read the first case, not the second case. And notice that that court actually describes the elements of contracts a little differently than in our book. And that's pretty much par for the course. There's going to be courts that use slightly different language to mean the same thing. Okay, that's it for now, and I'll see you next, or I'll talk to you next time.